Welcome to the Computational Antitrust podcast. My name is Thibaut Schrepel. I am a faculty affiliate at Stanford University Codex Center, an associate professor of law at the VU Amsterdam, and the creator of the Computational Antitrust project, which explores how legal informatics can benefit antitrust law. The project brings together over 65 competition agencies and 35 academics in the advisory board. Each month or so, we publish an academic article on the subject of computational antitrust. You may find these publications at computationalantitrust.com. Today, I am thrilled to be receiving Siying, an assistant professor in the Department of Economics at the Chinese University of Hong Kong. Siying wrote a paper for us entitled Economic Analysis in Antitrust Law, subtitle being "A Automated Approach Applied to U.S. Appellate Courts." So, Siying, first of all, thank you very much for joining me. I hope you're well, and I will start with a very personal question. I'm curious to hear how you got there. So, what led you to study computational law and here to apply that to antitrust? What is the reason behind all of your work and your PhD and your career?
Yeah, that's a great question to get started. Thanks for asking. Actually, as you know, I was trained as an economics PhD, and I was at least in the middle of finding a topic for my dissertation. Before that, I did an internship in an economic consulting firm where we sort of work with lawyers to prepare economic analysis, which might later be presented to the judges. Right? It was there that I figured that actually the economic analysis can be quite complicated. So a lot of what I learned during my first 3 years in the economics PhD program, especially in the class of industrial organization, got actually some of the methods or some of the models got implemented in the actual case analysis. So that was kind of amazing to me because I didn't anticipate that to be so complex. And then the next natural question for me is this really something that the judges could take very well? So that's how these things started. And then sort of why I use computational methods, well, that was another story. I've always been interested in some of the latest advances in machine learning or computational linguistics, using text combined with some algorithms to produce insights, right? So then it's something just all these things came together, and then I said, oh, why don't I just try to measure how much judges actually know about economics, because it will be super exciting to sort of position all the judges onto a space where they have some knowledge of economics, but potentially very different from each other, right? So that was how this started. And besides, I was in Chicago, so there was a lot of intellectual affinity to these kind of thing, right? So in the end, I was fortunate enough to not only be talking with my advisors in the economics department, but also across law schools and also business schools. I got a lot of feedback on that, and so it turns out that this is something that is still relatively this whole thing about computational tools being applied to law or economics still relatively young, and I think this is a fantastic field to explore. So in my dissertation, I was measuring judges' economic sophistication using antitrust opinions and as well as securities regulation, everything. So that was the backdrop of my my research interest. And then this project that I wrote for a computational antitrust project was something that was based on that dissertation research. And my current interest is still trying to sort of incorporate computational tools to understanding patent system, which is again something that both lawyers and economists are interested in.
And
so I guess
what about the linguistic part? Are you a fan of literature, or why this? Because of course there are many different ways by which you could apply computational tools, but you've chosen to study language. So what's the reason behind?
That's a legitimate question, and I would say among all machine learning algorithms, I was most interested in those applied to text, and I think part of the reason was I was partially fed up with the mathematical models or all those things built from abstract things, and I would like to work with the narratives or those text written by human. I think it's a really great way to leverage those information. Yeah. So I guess for
Yeah.
literature, I
Well,
don't know about that. I do enjoy humanities and all these, but I'm not sure that's not like a sufficient reason for me to dive into this.
yeah, not specifically. Regarding the use of mathematics, especially in economics, to everyone listening to us out there is a great paper by George Akerlof, so a Nobel laureate, that he published 2 years ago entitled The Sins of Missions, and precisely making that point that maybe we've been too obsessed with using mathematics. Not that we should not use it at all, but that qualitative and new ways to approach the space are also interesting. So that leads me to your paper, and my usual question is, uh, uh, and I know it's a challenge, but if you could, for everyone listening to us, summarize the key finding of your paper in just 1 or 2 minutes.
Okay, let me try to do that. Okay, so um, my paper was, as I said, kind of an extension of what I did previously, which was to trying to measure the extent to which economics analysis is being used by federal judges in antitrust law. And before in my dissertation, I work with district court judges, so that was one thing. And now I would really love to see how the same kind of methodology might be still applicable to studying the circuit court judges. It would also be interesting to compare these two um, levels of court to see how conceptually, they might use economics differently, and whether the methodology that I apply actually reveals such nuances and differences. So that is like the main, uh, I would say, the main content of the paper. Like in terms of findings, I find something both in the aggregate and also more precisely for each individual categories of antitrust violations. So to summarize briefly the findings, on the macro level, I find ever since the year of 1940s until today, the use of economics language that is closely associated with modern industrial organization has been on the rise. And in particular, seems to be a market rise around the 1970s when the Chicago School came of age. And then breaking that aggregate trend into several different categories of antitrust practices, in particular mergers, monopolization cases, and price fixing and other conspiracies, I also find persistent and substantial gaps between among these three categories in terms of the extent to which economics is being used in these cases. So um, there are some like micro findings as well when we zoom into the actual words that judges engage with, and whether the economic jargons are actually implemented, and these are also super informative, and I have some findings which help me to understand how the circuit judges are sort of adopting economics in a slightly different way than what the district judges are doing. Yeah.
Yeah, all right. So there is a lot to
Mm.
unpack. Let me start with the macro. You perform your analysis on over 7,000 different unique opinions. And you indeed covered the antitrust cases decided by the circuit court in the United States from 32 to 2016. So it's quite a broad sample, and you derive several lessons from that. And as you just mentioned, one of the macro lessons or findings is that the adoption of economic reasoning has changed over time, and you explain that it has changed also at a at a more a specific level if you look at different types of practices, and namely here you make a distinction between monopolization on the one hand, merger control, and price fixing cases. So could you explain what you found in this regard, and if indeed you have seen the use of economic concept being more prominent in one space than another?
Yes, certainly. So let me start with the sort of the aggregate trends that I found. So just to remind you, yes, as Steve said, I my studies sort of take all the universe of antitrust opinions ever written ever published in circuit courts since 1932, right? And that's like qualitatively speaking, from all the past archival studies or case studies that we had, that's roughly when economics started to have some discernible impact on antitrust actual antitrust adjudication. So this time period was kind of broad, um, and I think I would so the idea is to have some measure of economic reasoning for each individual judicial opinion, and then we're going to aggregate or take the average of that measure year by year. So in this way, we can sort of construct a time series to see like how this adoption of economics changes, right? So I think like before I go into the detail, I also want to sort of qualify what I'm doing and what I'm not doing in this study, because that I think that will help both clarify and also avoid some misunderstandings. Okay, so the when I said economic analysis, I of course this is not something that is fixed, right? It's not like a fixed notion. Okay, it's always this body of knowledge. As we know, like every discipline evolves, right? And the languages they use also sort of changes over time. So the because like what I'm most interested in is how nowadays these like sort of economics learnings are being used in the courts. And I first got amazed by seeing something like price elasticity, market share, like entry to barrier even. So these are like really economic jargons, but they do make their way into the court. So I was interested in how these, I'd say like modern industrial organization learnings, which are developed around 1980s, okay, how this body of knowledge was incorporated into antitrust and whether there has been this increasing trend as we would expect over time to happen, right? So even though there was these like previous qualitative studies that on the basis of Supreme Court cases claim that yes, there has indeed been both more economics being used and also more advanced learnings being incorporated into these cases. So my measure is capturing the adoption of such body of modern industrial organization knowledge being used in antitrust law. And what I found was these steady increase since 1940s until today. Right. So that was the aggregate trend that I found interesting. And then on a more micro level, I guess the first of all, why am I doing this? Well, that's because if you just look at the time series and you see an increasing trend, that doesn't necessarily mean for each kind of practice there is this kind of increase, right? It could just be an artifact of changing mix of like type of cases that are being decided, right? Suppose for price fixing, it has always been relatively low level of economic knowledge being used. And then for mergers or monopolizations, there also always been a high degree of economics being used. And if it's actually the case makes that it's changing, then you would likely see the same kind of rising trend when in reality nothing substantial changes within each category, right? So by breaking down the aggregate trend into these three broad categories of antitrust violations, and I'll be able to sort of go into more detail to see whether what I think I'm claiming is true, namely, like substantively, there has been this change or this increase in the level of economic sophistication. And more specifically, if we unpack the trend across these three categories, then we see these on the bottom there is price fixing conspiracies, right? They don't use as much of economics as the other categories did, and that is intuitive because in price fixing or conspiracies, typically the rules are per se instead of rule of reason, so there is not a lot of space for discussion about like market share, market power, or the potential anti-competitive impact, right? So on the other hand, if you look at mergers or monopolizations, then a typical sort of the legal doctrines requires that the parties address questions such as whether you have market power, how do you show that from using the data, and what is the likely anti-competitive impact. So to answer all these questions, then you would inevitably involve discussion of economic evidence and so on and so forth, right? So it's like we can see this persistent gap between monopolization mergers on the one hand and then price fixing conspiracies on the other hand. So this trend,
Yeah.
yeah.
So I have two reactions. The first is, and that appears clearly in your paper because you do explain indeed that you are trying to measure how economic concepts are being used over time, which requires you to know the space pretty well, meaning here economic literature but also antitrust. If you have no idea about how antitrust cases are being decided, you wouldn't know that barriers to entry and other concepts are being used and developed and used in the 70s and the 80s. So I think you could say it's one of the limits if you wanted to expand such a study, let's say in privacy cases or tax cases or labor issues. If you don't know the space pretty well, you wouldn't know what to be looking for. That's one. The second one is it seems to be intuitive indeed that you will see less economic analysis in price fixing cases because per se violations, but maybe not so intuitive. And let me explain why. In Europe, we don't have per se violations, but we have by object violation, where the difference is that you can, at least in theory, always justify the practice. But what you find is that courts, to make sure that a practice fits within the by object box, will actually use economic analysis to justify why the practice should be studied into a by object box. So you could potentially see the same in the United States, right? For the courts to say it's a per se violation, that they will use economic expertise to say, yes, it's this type of practice and therefore it is per se infringing antitrust. So very interesting finding. Going back to now something which is a bit different and also fascinating in your paper is the study of how courts rely on economic concepts. So here we live the substance of antitrust and look at judges and courts. You find, and I'm going to try to make it clear, that district courts tend to use economic terms when evaluating factual economic evidence, whilst circuit courts are more likely to introduce economic principles key to articulating legal doctrines. And you find that economic terms do not appear that often, if not at all, in appellate courts. So my question then is the following. If that information is to be helpful to practicing lawyers in how to shape the argumentation, would you indeed advise those practicing lawyers to use those findings as something relevant for when they will draft and send documentations to those courts? And on a more substantial basis, so that's two questions in one, would you say that we need more uniformity? Because this kind of differences between courts is not something that makes the job of practicing lawyers and companies easy.
Yeah. Thanks, Thibault. So first of all, thanks for your comment on my previous few lines of speech. That was on the point, right on the point. Your especially your part on price fixing not being so intuitive, and that's absolutely true. And actually, in the paper I did in the footnote address that. So there was an explanation for why still we see this lower level of economic analysis compared relative to the other two categories. Yeah, but that was certainly a valid point. Okay, so now in terms of the so to answer your first question, whether or in what way my toolbox or my analysis can be helpful for the lawyers who are practicing before the court, right? So I would say in the first sense, my methodology can be sort of treated as one form of legal analytics, which in some way, like Westlaw or LexisNexis, allows you to retrieve information more efficiently, right? So, but those are certainly commercial licensing websites, so you have to pay the fee. But I'm developing more like a for free version of that, and you can specifically, if you want to know how the judges are evaluating economic arguments and you want to go quickly into that section, then this, I think my methodology would allow that to happen more quickly for you as a lawyer. On another note, so these, I think I guess the other valuable contribution of this methodology is to help you compare across different judges or previous cases how they differ in terms of using economics, and that might help shape your argument. For example, which type of economic analysis is deemed by a particular judge as non-admissible, right? That is something that you might be interested in. And then, so I think so for the next question on comparing this district court versus circuit courts, so whether there should be uniformity or not, I think it might be helpful to first of all summarize a little bit what exactly are being talked about in economic terms on both levels of court. Okay, just to serve as a reminder. So for district courts, as we know that district courts juggle with both questions of fact as well as questions of law, right? So in antitrust, questions of fact might be what is the market share in this case for that product, and then a question of law would be something like what is the correct approach to market definition, and that you might have several different answers, and now like the legal doctrine has something to say about that, but it is still a question of law. And then another example of question of law would be whether something should be decided in a per se way or based on rule of reason analysis, right? That is also a question of law. So in district courts, these type of questions are considered at a later stage after the fact-finding phase, right? So typically in district courts, I think the majority of economic analysis come from this fact-finding phase where the experts from both sides will present their empirical studies, try to convince judge that there is or there isn't anti-competitive harm involved in this case. And then the judges are going to evaluate during trials both sides of arguments and then make a decision based on that. Right, so in district courts, you see two ways in which economics are being used, or just from what I just described, there are two. There's a question of law part and there's a question of fact part. If you go to a circuit course, then the fact finding is mostly not there, right? Because just by nature, circuit courts primarily deal with questions of law, and they rarely revisit the facts that district court has already trialed. So in that case, questions of law is the primary thing that these judges are concerned about. And I would like to argue that it's not my original argument, but from my quantitative study, it sort of, again, reaffirms this notion that even in appellate court or in the Supreme Court level, so these legal doctrines in antitrust law has been so thoroughly infused with economics that it has almost become impossible to talk about antitrust law without invoking any economic concepts. I can give you two examples, but I don't know if we have time for that. It's certainly in the paper.
Please go ahead.
Yeah.
Yeah. No. Go ahead.
Right. So yeah. Like, if you look at appellate court's question of law type of thing, then say there is one channel where economics is being used, um, we all know there was this shift from per se legal rules to rule of reason for tie-in practices, right? If you tie a product to another when you sell things, and initially you were deemed to be violating antitrust law on a per se illegal basis, but then over time things changed, and eventually, nowadays it is judged on a rule of reason basis. So how this actually happened has a lot to do with economic theory being developed around tie-in practices, right? In particular, the learnings in industrial organization tell us under what conditions, or if at all, tie-in might be anti-competitive. It might harm consumers in terms of prices. So with these kind of new development in economic theory, which made in a way into the courts, then judges realized, okay, the per se illegal rule might not be a sound legal principle, so we'd better shift to a rule of reason rationale. Right. So that's like one example of a question of law being discussed in courts. And then whenever this happens, the judges tend to refer to economic literature, right, or law and economics literature that sort of serves as a source of wisdom, or like a non-binding authority on judges. So from my textual analysis, you can see that judges refer to, say, George Stigler's writing, or refers to Principles of Economics by Samuelson, or say Antitrust Paradox by Judge Wilbur Bork, etc. Right. So this is one way in which the circuit court judges engage with economics, and I would say it's like kind of happening at a higher level than the fact-finding things, which primarily involves running regressions or empirical analysis to answer some like factual questions. Yeah.
So something you've mentioned is that you may see differences between courts, but also between judges. And you found here more specifically that, and this wouldn't be a surprise to the antitrust expert listening to us, that Judge Posner and Easterbrook rank first and second amongst all the judges in the dataset as to how much they rely on economic concepts. Stephen Breyer ranks third, which might be more of a surprise. And perhaps more interestingly, you find that half of the top 10 opinions in your sample are written by judges in the Seventh Circuit. And you say it's not surprising considering that Posner was there and proved to be influential over other judges. So now looking at the neo-Brandeisian and maybe the push away from economic concept, I'm curious to hear if you know how long it took Judge Posner to produce these effects on the court. And I guess the sub question here would be, if the neo-Brandeisians are to change the space, how long might it take before we see if they made it or if they failed at doing so?
Yeah, that's a great question, and I think you're sort of posing the question about new Brandeisian movements in the context of like law and economics movement around 1970s is an excellent entry point into the discussion. So let me first start by saying a little bit about what I find about Posner and Seventh Circuit across the board. Okay, so the claim that Posner, after he got appointed to the Seventh Circuit bench, there was this like dramatic shift in antitrust jurisprudence on the Seventh Circuit. That was something first described or stated in the 1983 paper by a legal scholar who, through a series of case readings, close readings of cases have, written in the Seventh Circuit, he found that there was this immediate response in the Seventh Circuit following Judge Posner's appointment. In both, so there were like two things happening. First of all, there was rapid diminishment in the scope of protection provided by Section 1 Sherman Act. And the second thing is there was also this ideological shift toward embracing the Chicago school understanding of economic efficiency being sort of the sole goal of antitrust enforcement. So these things, I think, through his close reading of the cases, he claimed that Posner had an immediate impact on the Seventh Circuit. But I would like to add to his point by saying that it is not only after Judge Posner got appointed had antitrust been transformed. It was actually before that. So it was like the in the backdrop of these law and economics movements, antitrust jurisprudence changed from the Supreme Court when Judge Posner and Judge Robert Bork published two influential treatises on this topic. Right, one was so Posner wrote the book The Economic Analysis of Law in 1973, and then Robert Bork wrote the famous Antitrust Paradox in 1976. Even before 1970s, there was already this like frequent interaction between Posner and a group of scholars that have been identified with Chicago School, say Aaron Director, and there was George Stigler. Right? So you have this group of people that have already laid the foundation for law and for the intellectual foundation for law and economics, and with the sort of the institutional efforts, not only involving these prominent intellectual figures, but also the broader network of lawyers, of law school students, and judges already on the bench. So this movement gained traction, and they made their impact on Supreme Court thinking about antitrust, and then these sort of later diffused into the lower courts, and then with their continuous input into these intellectual sort of thinking, we do see, in a fundamental transformation in antitrust law happening around 1970s, right? But of course, I would say like the appointment of key figures into the benches is certainly a very important step in making this happen. But we should also not ignore the broader intellectual landscape happening somewhat before that. And that has important implication for how we think about the new Bernaysian movement, I think. If I may, I would like to sort of refer us to one recent New York Times writing, which sort of pointed out the problem with the current New Bernaysian movement and how it might actually have produced real impact on antitrust or on the face of antitrust. So currently, what we see is the appointment of Lina Khan to FTC as a chairperson, and then there's several important other positions being filled with advocates of new Bernaysian sort of antitrust. But what we do not see yet is appointment of key judges to the courts. Right, and that might be something that should happen if we were to see something like a sea change in antitrust jurisprudence. And of course, we're still too early in the game, and we haven't seen really like a well laid out intellectual foundation for the new Bernaysian movement. How would you address the criticism coming from the status quo, Chicago School or like Harvard School or post-Chicago School economists and judges who are also sort of into that kind of narrative? So I think it's still a long way to go, and maybe you need to think about what the intellectual input has to be in order for something different to happen.
Yeah, to be strategic. Yeah. It's a question I've been discussing in many conferences and with many colleagues. Some of them are saying that the only way for the neo-Bernaysians to make it, quote unquote, is to pass legislations, because indeed the courts are not in their favor. And with the midterms election, it might become more complicated. So some people are under the impression that that's it. They won't be able to make it. Whilst I've also heard that even within the big law firms, uh, a good proportion of the young associates are leaning towards this kind of concept. So it might also be that it's a ground movement, and that therefore there are chances are that they will eventually overtake the space. But I like the idea very much that indeed we should not insist on. Of course, key figures are a good catalyst and a good way to try to frame something, but often you see that it's actually more emergent than just one person trying to influence everything from the top. So that's I think a very key and important message. Moving on to, and this will be my last question, or almost the last question, the more methodological part of your paper. You do rely on a dictionary based method. Long story short, the idea here is to create a list of pre-identified words which will capture here economic concepts and ask the machine to count how many times those concepts or words appear in proportion to the length of the text. A question I had, but you already kind of answered that, is which words did you have on the list? You mentioned a few, and I'm maybe curious to hear from you regarding. And actually, we asked computer scientists to read your paper when this was still a draft, and they confirmed that indeed this was the best approach for what you wanted to achieve. But could you explain why it's better for the purpose of this analysis to do it that way than to rely on, let's say, topic modeling, for instance?
Yeah, for sure. I would love to share my thoughts on the methodology. So just to again reiterate the economic terms that I'm able to identify using this dictionary-based approach. So the economic bigrams, which are like two-word combinations, that are used most often in the court, are terms like market power, market share, marginal cost, elasticity of demand, and barriers to entry. Right? These are terms that are both frequently used in economics treatises, and also they are being adopted by the court and actually used quite frequently. So, how do I construct, or how do I derive these predefined list of words? Well, one traditional way would be to just take a look at the economic terms and write down some of those or all of them that you think might be used by judges. But what I did is more automated approach, meaning that I choose a textbook that I think is representative of the body of modern industrial organization, and then I'm gonna supplement with another legal book, which I call a training library, to help me filter out the terms that are not exclusively economic. Right? So some examples of terms that appear in both economics and non-economic treatises would be like United States, Sherman Acts, and these you wouldn't associate with economics, right? So my methodology accounts for that, and in the end, I'm able to, from this book, derive a list of bigrams, which also have the like associated weights measured by how frequently they appear in the textbook. So terms such as market power, market share would receive a high weight, whereas terms like Nash equilibrium will receive very low weights, depending on how much they're used in textbooks. Yeah, so and once you have that predefined list of terms, then you can just go and look at the judicial opinions and count how many times those words appear, and sort of do some normalization with respect to the length of the opinion. So the technical part is left in the paper. And so back to your question about the choice of methodology, why this dictionary-based approach works better and is preferable in my specific context over something like topic model. Okay, so the way to think about this is for topic model to work well, you need to think that there is potentially this topic in the body of text, right? So for me, it would be like imagining there is a separate topic called economic analysis, and there's going to be a list of words that I can, for some certainty, say is something like economic analysis. But I did run the analysis using topic models, and I tried experimenting with different choices of K, which is the number of topics. And what I find is, unfortunately, no matter how many topics you look at, you specify for that model, there's just no way you can get a single or several topics that seem to be cleanly on the topic of economic analysis. To give you some idea, the topics that I am able to label in the paper is actually a mix of legal rules, fact patterns, and antitrust claims. So the topics that I'm able to uncover from these unsupervised learning methods are like procedural issues or class action settlement, labor, antitrust issues, so on and so forth. So it doesn't seem I will be able to find using topic modeling something that I actually am interested in uncovering. So now, why does dictionary based method work in this case? Well, this has been something that social scientists and economists have already realized over time, that dictionary based method is simple, it's very easy to use, and can be very robust when the information in your data is kind of weak, but you have like kind of a strong prior knowledge about the signal that you want to extract. And this is exactly what is happening in my analysis, right? You do know what is, of course, it requires some expertise in knowing these body of law, knowing what economics knowledge might be useful for judges. But once you have that expertise, then it will be straightforward to construct a training library or a dictionary. And then you can just take that dictionary to the judicial opinions and do the counting. It's as simple as that. This has the demonstrated advantage of being transparent. There's no uncertainty. There's no reproducibility issues. You will always get the same thing every time you run it. So essentially, there's like no statistical learning going on. It's more like a simple counting measure.
Yeah, and again, it's a good example of how if you combine human expertise with computational tools, you may end up with good results. And it's an important message. And we had this discussion many times, including with competition agencies. Some of them which faced the issues where if they hired one or two computer scientists or data scientists, they just constantly were asked, could you please develop a tool so that you can solve antitrust? And it doesn't work that way. You need the expertise, and that's the combination of the two that may lead you to a good result. That leads me to my final usual question, which I know is impossible to answer, but I still like to ask the question. Where do you think we will be in, let's say, 10 years from now, in terms of what we can achieve in the field of antitrust using computational tools? Whether we here look at the analysis of language or any other tools that you may think of.
Yeah, that's a great question
and impossible.
Yeah, it is impossible to make a forecast for future. Yeah, but I do think that computational tools will be increasingly useful and also probably used by antitrust agencies. Like some of our previous contributors to these projects has already discussed, like the most straightforward way that these tools can be implemented is for agencies to gather data to run some build a predictive algorithm in order to screen the suspicious conduct, right? So like for merger analysis, we already know that in the United States, FTC has this pre-merger notification program. They have these procedures for merger reviews. And indeed, they can leverage the amount of data, both from past consummated mergers and as well as from the ongoing suspicious mergers, and once they request these data and they have like abundant data, then they can work with them to build a predictive model to get started, and that way they can sort of be more efficient in screening. And I think that would be already a good improvement over what they have been doing over the years. Um, but going beyond prediction, or what else can we do? Well, I think that's that's probably a harder question and something that's definitely worth exploring in greater depth as we move along.
Well, and the beauty of it is that we have no idea,
Yeah.
right? That makes the field very exciting. I think you're referring to indeed a paper that we published last year by Casey and Niblett on the use of microdirective, or the making of microdirectives by the FCC using the 30,000 merger decisions that the agency issued in the past. And I look forward to discussing those subjects with you. This is now the time to close this conversation, but I want to let everybody knows out there that we are organizing our second annual conference. It will be online December 5th, 6th, and 7th. You could register for free on our website. If you just, again, Google computational antitrust.com, you will go to our website, and there you could register for the conference. Siying will be there with us to further discuss the types of subject that we've been discussing today. So I very much look forward to seeing you there, and to all of you out there also listening to us. But for now, it's been a real pleasure seeing again. Thank you so much for the time and for the effort in investigating the space. And up until next time, take care of yourself, and if you can, someone else too.
Thank
Bye
you.
bye.
Bye, Thibault.